And welcome back to American Agenda. I'm Heather Childers along with Bob Sellers. Florida Governor Ron DeSantis signing a controversial bill aimed at stopping big tech companies like Facebook and Twitter from booting people off their platforms without good cause. Now, DeSantis says that the bill targets Silicon Valley elites, fining each tech company up to $250,000 per day for banning or suspending accounts. Well, this comes after major social media platforms banned former President Trump, of course, and targeted other political figures. For a legal perspective now, let's bring in attorney and distinguished university professor at Touro College, Thane Rosenbaum. Thane, always great to have you with us.
Thanks so much.
So it's something that we've been talking about ever since we first heard about Governor DeSantis proposing this, and now he signed it into law, is how he could actually do this. How could this, in fact, be legal?
Well, Heather, it's legal on one level, which I haven't heard anybody talking about, which is to say that Facebook, YouTube, these platforms are violating the state of Florida's antitrust laws. Right? They're monopolies, and they're monopolies that harm consumer and political welfare because they have control over the infrastructure of news. The government, the federal government, could take the same position and override Section 230 of the Communications Decency Act. But I think the best argument Florida has is to say that these internet companies are playing favorites on opinions. They are not neutral. They believe in some viewpoints, and they are opposed to other viewpoints. They like some candidates, and they don't like other candidates. For instance, how is it that Ayatollah Khomeini has a platform on Twitter when he believes in killing apostates, women, homosexuals, and Jews, but Donald Trump doesn't have the same platform on Twitter? Why? Because he questions the last election. So there's an example of anti-competitive behavior, a predatory behavior that favors one side over the other and violates the very public trust that's supposed to be protected under the antitrust laws.
So there's the antitrust issue. Right. There's another question that I would have. I'm not the expert, that's why we have you here, but there's something called the public square.
Right.
And so the government is not allowed to quash your free speech. But there are places like at the mall or at the town square where maybe it's owned by a private entity, but people are still allowed to get up and say their piece. Is that something that should apply here also? Should Facebook and Twitter and those other places be considered the public square?
Well, remember, the First Amendment and free speech only applies to government regulation, right? Not private regulation. Right. For instance, Colin Kaepernick was prevented from taking a knee because his employer told him not to. So that's different. So these are private entities. But on the other hand, as I said before, they have obligations like public utilities under the public trust because of the nature of their power. But remember, Bob, I love that you brought up the idea of the public square. What you said before is exactly right. This is what our founding fathers wanted. People to go to the public square, and everyone who had something to say would put down a soapbox. They would stand on the soapbox and make a speech, and everyone got a chance to walk around and see who they liked. But that's not what happens with social media companies. Why? It's called a news feed. They feed you. Their algorithm decides what you get to see. So that's another reason why that this doesn't have the same First Amendment issues, free speech issues. They are completely in control. They decide what's in your news feed. They decide what ads to show you. And they decide what opinions to favor and which to disfavor. So again, it puts them in a very different position. And for them to make an argument that they're the public square is really disingenuous and intellectually dishonest.
It really rises to whether or not you see these companies, I guess, so as individually owned companies with a right to do what they want to do versus being, like what you said, part of this antitrust issue, part of the public square, and being protected under Section 230.
That's right. And remember, that's right, 230, remember why we gave them this protection. It's very important, Heather. There was a time, you're too young to remember, in the mid-90s, no one ever heard the word internet. No one knew what email meant in 1996 when we gave them this exemption. And you know why we gave them this immunity? because we believed that they had no opinion on who got to drive on the digital highway. That they were laying the concrete, the mortar, and they had no particular preference. They weren't going to pull anyone over. They weren't going to take someone's license away. They weren't going to say, you can speed, you got to slow down. They have lost the purpose for the immunity and the exemption. And
but
that's
Al Gore created the internet, right? Didn't Al Gore create the internet?
He should have thought of this.
Yeah,
he should have thought of this.
All right, hold on, Thane. Don't go anywhere, because now we're going to bring in our panel to weigh in on this conversation once again. So if anyone